All right, thank you. Court calls the case of the people versus Candace Butler.
Alexander on behalf of the people.
Ready again, Judge. Torshell Feaster, Assistant Public Defender, on behalf of Miss Candace Butler. Miss Butler, please state your name for the record.
Candace Sierra Butler.
Thank you, Judge. I met with Miss Butler earlier this week and again this morning. We reached a late plea agreement for a no contest plea to a misdemeanor that may have met your file. It may not have. If it did not, I request an
Well,
adjournment.
I have the plea form. Is this the other report you sent over because you didn't think we had enough paper?
Yes, Judge.
Oh, okay. Well, we already had it. I reviewed it, but okay. All right.
Okay.
I just wanted to double check. Okay. So I have a plea agreement that indicates that the defendant will be, well, okay. I see it. It's down at the bottom. We'll be pleading no contest to counts, the stated count 2, count 3, as well as an added count 4 of attempted resisting and obstructing the 1-year offense. Upon our successful plea to those charges, count 1 would be dismissed. That is the court's full understanding of the agreement.
Yes, Judge. I believe she's also going to plead guilty to the bond violations also, Your Honor.
Okay, she's also pleading to the bond violation.
Yes, Judge.
Let me make a note of that. I don't, hang on one moment. I don't have an ROI, or do I? I don't have one here, but I can. That's okay. Yeah, go if you could, I'd appreciate it. All right. Ma'am, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Did she freeze on me? Ms. Butler, can you hear me?
You're breaking up a little bit.
Yeah. Okay. Let's see if we can do this. If you don't hear something I say, then let me know, okay?
Okay.
All right. It's court's understanding you're going to plead no contest to 3 misdemeanor charges. Count 2 and count 3, both are domestic violence. They're punishable by up to 93 days, $500 fine plus court costs. You understand that, ma'am?
Yes.
Also, the added count 4 of attempted resisting and obstructing, that's a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
More or less.
Okay, I have to make sure you understand what it is. Let me start with this. First of all, a no contest plea means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
All right. Second thing you need to understand is that, well, first of all, I will be reading the police report and have reviewed it to form the factual basis. You won't be saying anything about that. You understand that? Ms. Butler?
Sorry, you're breaking up. No, I didn't hear you. I'm sorry.
You
Yes,
didn't
I can
hear
hear
me?
you now.
Okay. You understand that I will be reviewing the police report to form the factual basis for the charges. You understand that?
Yes, sir.
All right. The next thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Is that a yes?
Yes. Yes.
All right. I further have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
Is that a yes?
Yes.
Okay. Oops. Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. So, ma'am, to the charge of domestic violence contained in count 2, how do you plead?
No contest, please.
Yeah. Yes,
Well, I need to hear you say it, Ms. Butler. I got you.
no
Okay.
contest,
To that same charge contained in count 3, how do you plead? She's freezing.
no contest. No
All right.
contest. No
Got it.
contest,
To the added count 4 of attempted resisting and obstructing, how do you plead? We're not going to be able to do this.
no contest.
All right, Miss Butler, we're going to shut your video down. Let's see if that's going to help us. Can you shut it? It's off. Okay, Miss Butler, can you hear me any better?
I hear you about the same.
Okay. Maybe you won't break up.
Okay.
All right. So just so that we're clear, you're pleading no contest to all of these charges, correct?
Correct. Yes,
All right.
sir.
You understand that by pleading no contest, you will not have a trial of any kind. Right. We're going to have.
Yes.
Yeah. Okay, Miss
Hello?
Butler, are they going to move her?
Yeah.
Okay. Miss Butler, I'm gonna stop right
Yes.
here.
Hello.
We'll get back to you. They're gonna move you to a different area, okay?
All right. Thank you. It's breaking up. Okay.
All right, court will pass
Thank
this
you.
matter briefly.
Thank you, Judge.
Court calls the case of the people versus Gino Hearn.
Alex Jablowski on behalf of the people, Your Honor.
Your
Yeah.
Honor, Gina Noveski, First Assistant Public Defender, with and on behalf of Mr. Hearn, who is present.
Yes.
Mr. Hearn, can you state your name, please?
Gino Hearn.
And counsel, I did receive a media request. Any objection?
No, Your Honor.
All right. Okay, what are we doing on this case today?
Your Honor, Mr. Hearn and I did meet earlier this week, and there is some possible video discovery that we would like to receive before we decide how to proceed. And I would ask to address bond.
And how much time are you gonna need? You want 21st or 28th?
Let's do the 21st.
All right.
Please.
Probable cause conference will be adjourned September 21st, 2023, 9 a.m. As to bond.
Your Honor, Mr. Hearn is 19 years old. He lives with his best friend in Taylor. He also has plans to enroll in GED classes. I don't believe he has any prior criminal history. He has a very supportive mother and 2 minor children. Prior to his incarceration, he was working full-time at McDonald's. So he does have employable skills if he's not able to get that job back. He's asking you to allow him to be released on a personal bond or a personal bond with a tether, so that he can get out, get back to work and get things back on track.
Response from the people.
Your Honor, we believe that the bond as initially set was properly set. This was quite a significant incident involving the assault of a couple of officers, including some injuries. As I recall, there was biting involved from Mr. Hearn as well. He was very combative, and we believe that the bond as set will ensure that he not only appears for future court dates, but also abides by court orders, as this is charged as resisting, obstructing, and assaulting a police officer. Thank you.
What do you have as bond currently set? I have 20. I'll be honest with you. I realize this is the defendant's motion to reduce bond. I actually don't think the bond is set high enough, but I don't have a request to increase the bond. I would just say that the information that I have is that he indicated that he would pay to have officers killed and that he would shoot the officers in the head, and that further that upon coming to the jail, I think the prosecutor was kind in what he said, but the reality is that he attacked and bit the corrections officers, had to be maced and then restrained. Given at least those indications, the court does believe that the defendant does pose a significant risk to the community. Motion for bond reduction is denied. since there wasn't a request to raise the bond, I will just continue the bond.
Thank you, Your Honor.
Thank you. Okay, I'm going to recall the case of People versus Candace Butler. Ms. Butler, can you hear me now?
Yes, Your Honor.
All right, I think we got you in a better place. You had pled no contest to all of the three charges, the two domestic violence charges and the attempted resisting and obstructing. Is that correct?
Correct.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes.
All right. Court has been provided, and there's numerous copies, but a copy of Northfield Township Police Department report for their case number 234347. Any objection to the court reviewing that report? Either one.
No, Your Honor.
No, Judge, read anyone you like.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court?
Yes, Your Honor.
You have, Judge.
All right. Court will accept the defendant's no contest pleas to counts 2, 3, and 4. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing will be set for.
There is a bond request, Judge, just so you know.
Pardon?
There will be a bond request, just so you know. If you-
Okay, go
if you-
ahead.
Oh, okay, thank you. I just wanted to hear it before you set the date or not. I did talk to Ms. Kirby about this case. Obviously, her main concern is about the substances and the substance use in this matter. And my understanding is Ms. Butler has no objection to wearing a scram. That is what I believe Ms. Kirby is requesting. If the court does release her, that it be on a scram tether. Ms. Butler does have housing. I believe she has a job. She's taking responsibility for this case and for the bond violations. So I don't believe there's an objection to her release on the scram tether, Your Honor.
And that's correct, Your Honor. We would just ask for the scram tether.
All right. Well, I found it finally, I think. That's all right. Sorry, my bad. All right. What is your current bond? I don't know why they don't put it in the front, but I think I got it. I got 5,000. Well, I had 5,000 personal, but then their bond was denied. Correct. Okay, what I will do is I will release it. I'll set her sentencing date for the 14th at what time?
9 a.m.
9 a.m. before Judge Fresh Hour. I will reinstate the defendant's previous bond at $5,000. Personal recognizance bond with the previous conditions are still remain in effect. You understand that, Ms. Butler?
Yes, sir.
Defendant is to be placed on a scram tether prior to her release. Thank you.
Thank you very much, Judge.
Thank
Your Honor.
you.
That's prior to release. I know you didn't, but I got you covered. Court does call the case of the people versus Ivan, is it Pasek?
We're ready.
Alex Chabalowski.
Your Honor.
Alex Chabalowski on behalf of the people.
Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Paycheck. Mr. Paycheck, state your name for the record, please.
Ivan Paycheck.
Your Honor, this is the date and time set for the probable cause conference. The contemplated plea has not materialized. We will set this matter for preliminary examination at the earliest possible.
Nice of you to join us, Mr. Brown. We missed you this morning during the waiver.
Well, I didn't want to hog up too much of the spotlight.
Okay, I'm just saying. Good to see you. We were worried about you.
Good to see you.
All
too.
right. Preliminary examination will be set for September 19th, 2023, 9 a.m. That is before Judge Valvo in person.
Thank you, Your Honor.
Thank
Can I
you.
have a word with my attorney?
Thank you. Bond will
I'll come
continue.
to see you, Mr. Paycheck.
Does call the cases of the people versus Wesley Walton, 2 cases. They're not here.
Good morning again, Jonathan Emmons on behalf of the people.
Good morning, Your Honor. Tina Saxon on behalf of Wesley Walton on case number 23F20648FY.
Your Honor, Gina Noveski, First Assistant Public Defender, but on behalf of Mr. Walton in 0969.
All right. I think what was just determined is that Mr. Walton is in the Wayne County Jail, which was
Yes.
not known. And so we have to then adjourn this matter out so that a writ can be prepared to bring him to these proceedings.
Correct.
He is not here. So I will adjourn these to the 21st. Probable cause conference, September 21st, 2023, 9 a.m. Bond on these matters will continue.
Thank you
you,
very
Your
much, Your Honor.
Thank you, Your Honor.
Thank you. Calls the case of the people versus Sheldon Underwood.
Nicole Hughes on behalf of the people.
Andrew Banis, Assistant Public Defender, with and on behalf of Mr. Underwood. Mr. Underwood, please state your name for the court.
Sheldon Underwood.
What are we doing?
Your Honor, Mr. Underwood has two requests. One pertains to bond, but the first request is for a 1-week adjournment to hire private counsel. He informs me that his family has already reached out and is in contact with one of the local law firms.
Are they going to be able to accomplish that in a week?
I did discuss that with him, and he believes so.
All right. I'm only going to adjourn it. Well, I'm going to adjourn it to the 21st, if that's what he's doing, because he's only going to get one adjournment to get counsel. So probable cause conference, September 21st, 2023, 9 a.m. Or his Zoom invite indicates yes, ask the bond.
Thank you. Mr. Underwood is currently held on a $200,000 bond on this case, no other cases. He is requesting a reduction to a 10%. That's still quite significant. I understand the charges are serious in terms of the fleeing, and there's also a third count relating to the vehicle. His main concern is to get back to work if that $20,000 bond could even be posted and continue making his child support payments.
Response?
Your Honor, please let me know when you're convinced and tell me to stop talking because I could go on for days about this one. First, the defendant does have another, he does have another case. He has a friend of the court bench warrant right now. So in terms of him wanting to continue to pay his child support, he's got a bench warrant for his arrest for failure to support. He right now, the bench warrant has a bond of $536 for past due payments. The defendant's bond is set in the amount of $200,000. I charged this case. I requested $250,000, and I am renewing that request at this time. The defendant took multiple interstate police agencies on a high-speed chase beginning in Toledo, Ohio. He fled from Toledo all the way up to Ann Arbor. The third charge that Mr. Banis mentioned, the thing that involved the vehicle, yeah, that was when the defendant drove his car directly into a Pittsfield Township occupied patrol car, which is an FA on a police officer. The defendant was fleeing from Ohio with an Ohio State helicopter following him into Ohio. Pittsfield, the Washtenaw County Sheriff's Office, as well as Ann Arbor, had to get involved in this chase. He was doing speeds as fast as 114 miles per hour on Michigan Avenue. He wasn't, not that that's even part of a speed limit, but he wasn't even on a highway when he was doing 114 miles per hour. In terms of him being a danger to society, his reckless fleeing and his intentional assault on a police officer while fleeing certainly demonstrates that he's a danger to society. And then, of course, he's a flight risk, given that he took multiple jurisdictions on an interstate police chase. He ditched his car on US 23, tried to get out and run. When the police found him, thankfully, he was compliant and didn't continue to assault them. And they were able to take him into custody at that time. He is, when they searched his vehicle, they did not recover a firearm, but they did recover a magazine that was empty, did not have any ammunition in it. Again, the people are requesting at this time that his bond be increased to the initial request of $250,000.
When he rammed the Pittsfield officers, were any of the officers injured?
Thank goodness they were not. The officer was not injured. His car was damaged to the extent that he was unable to continue to pursue the defendant, though.
May I make two very brief minor points?
Go for it.
First, at least according to ex-jail, I think the front of the court warrant has been resolved, but Ms. Hughes might have some information that I'm not aware of. As I read the police report, and this is no doubt a factual dispute, but as I read the officer's statement, and I'm not blaming the officer in any way, but as I read that statement, the officer hit the defendant's car. Now, how that happened, but that's how I read it. And I'm not
Does
saying
that help you? They're on a high-speed chase from Ohio. So the officer hits his vehicle, maybe to stop it and save other people. I'll let you go on, but go ahead.
No, that's it, Your Honor. Thank you.
Motion for bond reduction is denied. I will, and quite frankly, given the circumstances as laid out by the people, I think the $200,000 bond is set very low. I don't even think that the $250,000 bond is appropriate, because from Ohio to Ann Arbor, all of the individuals that would have been on that roadway, as well as once he got himself on Michigan Avenue doing those high speeds, he put all of those people in danger. He put all of the officers that had to pursue him in danger. And for no reason. And at any given point in time, given those speeds, somebody who could have been just out could have been killed. Court will set bond in the amount of $500,000 cash surety.
Thank you, Your Honor.
Court calls the case of the people versus Daniel Webster.